adjudicating authority. So payment of default through application. Prior to such application, before that, he has to do some process as per the process of laid down by the code or regulations of the IPPI. First, he has to issue the demand notice. But in case of financial creditor, that demand notice is not required. Why? Because the default is satisfied by the adjudicating authority, then they will admit the case. But in case of operational creditor, before approaching the NCLT, first he has to issue the demand notice. The demand payment of the amount, because he supplied the goods or he provided the service to the company, and the company is not paid the amount as per the stipulation or as per the agreement reached by the buyer and seller or the debtor and the creditor, needs to serve upon the corporate debtor under section 8 subsection 1 of the Insolvency and Bankruptcy. So he has to issue. And the appellant, particularly the facts of the case, what was happened in Mobilex Purusa? What was happened? The appellant, the Mobilex was engaged in a Star TV program, Nachi Baliya. So Nachi Baliya, that a particular TV program is the Mobilex engaged in a Star TV program, conducting the telephone voting mechanism also. If at all they like or not like, and what is the rank, and who is particularly, you are also seeing that from time to time, next who singers also contest is there. In your opinion, who is the first best singer, or who is performed well, or whatever it is there. Now it is all technology oriented, and thereby based on that they will declare the participant and they will declare the winners of the particular program. The appellant engaged in the respond company, engaged the respond company, the respond Kurusa. They are providing various services, whether it is taking the information, they're taking the particularly the calls or whatever the rating, all these things. They have taken the IT company particularly to oversee the ratings of that particular program, or who is the best singer or who is the best dancer, whatever the TV programs are there. Services relating to TV programs. And both parties are executed non-disclosure agreement. Whenever the services are provided, whenever the goods are provided, agreement is must. Otherwise, if at all anybody is not adhere the terms and conditions of the contract, then whatever the penalties are to be paid based on the agreement, that is as per the Indian Contract Act. In this case also, the TV program, both the executed non-disclosure agreement. Sometimes the information should not be disclosed to other, because the information may be the sensitive, or the information may be the confidentiality, etc. But once the services I am providing, if at all I reveal that information to others, then automatically I am not adhering the terms and the conditions of the agreement. So the appellant engaged in the respond company, Kurusa, for providing various services relating to TV programs, and both parties are executed a non-disclosure agreement. So Mobilex plus Kurusa, they have agreed reached one agreement. The non-disclosure agreement, that is NDA agreement, stipulated such a confidentiality obligation towards Mobilex. Once a Kurusa is providing services, the information is stored in the information of the Mobilex is stored in the Kurusa service, that is confidential information. They should not disclose to anybody. If at all they disclose the information, then automatically whatever their programs are there, it will turn into different shape. So that's why non-disclosure agreement is there stipulated certain confidentiality obligations. Confidentiality obligations, particularly in the banks also, they are outsourcing so many areas. In that areas, the confidential information of the customer number, customer address, customer cell number, customer email address, and whatever the basic information is there, they should not declare to they should not disclose to anybody because that is a confidential information. Even other also, the confidential information. So like that, in between the buyer and seller, NDA stipulated certain conditions of the confidential obligation towards Moblex during the period of time period. Kurusa raised a necessary monthly invoice. Once they have provided the services, naturally they will supply, they will they submit the invoices for the services rendered by them, for the rendered services. So every month they use it to send the particular invoice. However, Mobilex informed Kurusa about the payment that was subsequently withheld due to breach of the non-disclosure agreement. They have bypassed. The Kurusa is not to maintain the information confidentiality is not there. Then the Mobilex has told, no, I don't want to pay the amount as per the non-disclosure agreement. Then the conflict arises. Once they have not paid, they will wait for 10 days. After that, they will give the demand notice. If he is not responding, then they will file the case with the NCLT after 10 days, like that. So, however, Mobilex informed the Kurusa about the payment that was subsequently withheld due to breach of the NDA non-disclosure agreement obligations. Correct? Even suppliers also, I asked 1.75 centimeters grade iron rods. Even they supplied 1.76 instead of 7.5, 7.6, which is not useful for me. And if at all the sensitive information should not be revealed to others, then my total program will be problem. So that's why then Mobilex informed Kurusa about the payment that was subsequently withheld due to breach of the non-disclosure agreement. Kurusa sent a demand notice, naturally. And Mobilex under Section 8, first they have to send a demand notice of the insolvency and break due to non-payment. Once the Mobilex is not adhered, not paid the invoice directly sent by the Kurusa, then procedure will start, the process will start to recover the dues by the Kurusa. So the Kurusa sent a demand notice to Mobilex under Section 8 of the Insolvency and Bankruptcy due to non-payment of this one. Okay. Mobilex responds to the demand notice. Immediately, Mobilex also, they respond. Some of the people, they may not respond. They may not respond. The corporate data may not respond in some cases. But here, the Mobilex, they responded for the demand notice issued by the Kurusa. That there was a bona fide and serious dispute between the parties, inclusive of a breach of obligation mentioned in the non-disclosure agreement. We have reached the non-disclosure agreement, but you have not adhered or not followed the guidelines or terms and conditions of the non-disclosure. Thereby, I lost some business or my business turned into bad. So then the Mobilex and serious dispute between Thus, a bona fide and a serious dispute between the parties, inclusive of breach of obligation mentioned in the non-disclosure agreement. Then, Kurusa subsequently filed an application. That is the process. Once the invoice is submitted, he is not paid, and he told that a breach of contract. Second one, immediately he sent the demand notice as per the process mentioned in the IBC code. And after that, 10 days he waited and he filed an application with NCLT. Kurusa subsequently filed an application before NCLT and Mumbai and under section 8 issue of the notice and section 9 once he is not responded then he will file for initiation of CIRP of Moblex. Then the case has to be admitted or to be rejected. That decision has to be taken by the adjudicating authority. Today, what is happening? Once the particular operational creditor has filed an application, the NCLT is also asked the declaration that there is no existing dispute like that. If at all after admitting the case, if a dispute is there, it is a judicial time waste. So that's why whenever operational creditors are filing the case with the NCLT, they will ask the declaration also. That is affidavit. So for this transaction, there is no existing of dispute. Once existence of a dispute is there, then that is NCLTs or judicial authorities, they are not for the recovery of the loan, only resolution plans on. So Kurusa subsequently filed an application before NCLT under the section 9 for initiation for CIRP process of Moblex. The NCLT rejected the application on the ground that Moblex has issued a notice of dispute to the operational creditor. So once the case is to be filed, then they will ask the corporate data also. Corporate data told clearly there is a dispute, existing dispute is there. So once existing dispute is there, the case is not to be admitted, that is to be rejected. Like that, the NCLT has rejected that the admission of the case. So the NCLT rejected the application on the grounds that Moblex had issued a notice for dispute of the operational creditor. Then the aggrieved person, the appellant, he approached the appellate authority, that is NCLT. The appeal against the order of NCLT was subsequently filed by Kurusa, stating that mere dispute to the demand notice by the operational creditor does not amount to a valid ground for rejection of the application under section 9 of Insolvency and Bankruptcy Code. The NCLT told that the appeal against the NCLT was subsequently filed by Kurusa, stating that mere dispute to the demand notice by the operational creditor does not amount to valid ground for rejection of the application under section 9. So immediately, they naturally the Kurusa will approach the next higher up court, that is none other than the Supreme Court. So the NCLT clearly told mere dispute to the demand notice. Once the notice is given, some of the people, to avoid the CIRP process, they will tell something, but the proof is also required. What is the dispute? Why today only? Why you are raising the dispute? Why not earlier? Once I have given the demand notice, then you are telling that there is a dispute. What is the dispute? Why you have not escalated the dispute earlier? Why today you are raising the a discrepancy or a dispute in the supply of the stock or services. So an appeal against the NCLT was subsequently filed by Purusa, stating that mere dispute to the demand notice by the operational creditor does not amount to valid ground for rejection. It is not valid ground of the application under Section 9 of the Insolvency and Bankruptcy Code. The question before the appellate tribunal was with respect to clarification of a meaning. What is a dispute? What is the existence of a dispute? That clarification for the purpose of application under Section 9 of the Insolvency. Once the point raised, the file, the complaint, once the application submitted under what grounds, then only they will go into details of the particular. Here, they told a dispute. Somebody is talking about the existence of dispute, the terminology. Then the National Company Law Appellate Tribunal, for the purpose of this application 9, they clarification and meaning of what is a dispute, what is the existence of dispute. These are to be clarified. Then only they will go into the details. Section 8 provide the requirements which should be complied with the prior filing an application under CAN, under Section 9 of the IBC code. Correct. Once the operational creditor is going to file an application under Section 9, and he has to fulfill the process of Section 8 also. Whether Section 8 is followed perfectly or not, stage-wise, one by one, they will go into the details. Then, under Section 8, subsection 2 of the Insolvency and Bankruptcy Code, once the demand notice is served upon the corporate debtor, the operational creditor, the corporate debtor needs to inform the creditor for the payment of a debt or dispute. If it is already that is already paid by the corporate debtor, then he will furnish so-and-so data, so-and-so through NEFT or RTGS, I have paid the amount, or so-and-so, I have sent the check to you by speed post or register post. So here is served by the corporate debtor or the operational creditor. The corporate debtor needs to inform the corporate creditor about the payment of debt or dispute. Only two options. Option one is if at all he paid, what is the particulars of the payment, whether it is a NEFT or RTGS or check or set off of the loan. If at all already he has taken some particularly any debtor and the creditor is there, sometimes they will set off also. So all these things the corporate debtor has to respond. If any, within 10 days of the receiving of the notice. He should not drag up because it is a time schedule. We have to complete the process within 180 days. So the deadline is also given not exceeding 10 days after receiving the notice from the operational creditor by the corporate debtor. Section 19(9) proves that the right to file an application. Once that the process is completed, then only the operational creditor is eligible to, is getting the right to file an application with the initiation of the CERP after expiry of the 10 days. After expiry of the 10 days from the date of delivery of the demand notice. So normally, whenever we are giving the notice, we will send by registered post also. Even NCLTs, some NCLTs, even Hyderabad also, whenever such situations are there, they don't accept the postal, the courier acknowledgement. They will tell only the government services are available, particularly the speed post with acknowledgement is available, register post with acknowledgement. Because today what is happening means the courier people, they will throw in the office premises like that, and whatever the signature is, they will sign, and they will close that issue. That is not a standard process. So that's why some of the MCLTs, even in my case also, they told in one case, they told, have you sent the letter to the personal guarantor by Indian Postal Department registered post or not? I told about the courier. Courier is not accepted because there is no specific guidelines mentioned in the code or act, but the judicial authority, he suggested me or he directed me to do this one. Immediately, I accepted that one and I sent that particular notice by way of the registered post with acknowledgement due. NCLT allowed the Kurusa appeal ground that the reply to the demanded notice by Mobilex cannot be seen within the purview of section 8 to subsection 2 and 5 subsection 6 of the insolvency. The reply is delayed. 8 to what it clearly states, only within 10 days. He has to reply. So, but within the purview of section 8 subsection 2 and 5 subsection 6, the dispute, further the dispute also, if at all it is paid or not paid, if paid, the corporate debtor has to intimate the information about the payment particulars, amount about the RTGS or NEFT. If at all they send by check number, bank name, and all these things. And if at all that operational creditor also encashed, then the account statement also. If at all it is not paid, for what reasons it is not paid, and he has to send the particular agreement also, copy of the agreement. Then only they will cross-check that one. 5 subsection 6, dispute includes a suit or arbitration proceedings relating to the existence of the amount of debt or the quality of goods or services or the breach of representation or warranty. That is defined under the section 5 subsection 6, the definition part of dispute. The definition part of the dispute clearly states it includes, dispute includes a suit or arbitration proceedings relating to the existence of the amount of debt. That dispute for the existence of the debt, why the debt is not paid, what is the reason, and the quality of goods, if at all the goods are supplied, the goods are not up to the mark, the quantity is not up to the mark, the size is not up to the mark, and the breach of representation of warranty. Whatever the warranties are given or guarantees are given, then if at all they have not adhered that warranties, then the dispute will arise. Some people, they will tell this product is useful for 1 year. Even after 1 month, the product is spoiled, even though careful attention is paid by the buyer. So the breach of representation of warranties also. Not only that one. It is stated that a defense raised by the Mobilex was vague. Then normally the adjudicating authority will ask, what is the dispute? Why you are not paid that invoices raised by the Kurusa? And whatever the responses or defense raised by the Mobilex is even vague, no clarity. Clarity is missing. Clarity is missing, and it is motivated as the debt demand was not in connection with the non-disclosure agreement. At the time of the contract, particularly the supply of a service or goods, they reached one non-disclosure agreement. They told that it is was whatever the response given by the particular Moblex is not up to them. It is stated that the defense raised by the Moblex was big and motivated. The debt demand was not in connection with the non-disclosure agreement. Whatever the disclosure agreement, you have violated that agreement, that's why I am not paid. It is a disputed one. Like that, the Moblex has given a response to the adjudicating authority. Further, NCLT stressed upon the interpretation of a dispute. What is a dispute? What is the existence dispute? So they started in that one by one, they will digging that particular the importance of that particular terms. What is a term? What is the act says or regulations or any other references? So further, the NCLT stressed upon the interpretation of dispute, stating that dispute would not be limited not to only arbitration proceeding, but or suits shall include proceeding initiated before tribunal or consumer court or labor court, etc. But the old definition is different, the new definition is different. Old definition, they mentioned and also. So whatever the arbitration, that is replaced with OR also. If at all and is there and everybody will file one case with various the courts and other things, then for those companies, CIRP is not at all applicable. So further, NCLT is stressed upon the interpretation of the dispute. What is the dispute? Stating that the dispute would not be limited to arbitration proceedings or suits, but shall include any proceeding initiated before the tribunal or consumer court or the labor court, etc. Earlier definition. Later on, in 2018, the definition is slightly they have changed. Moblex went to appeal. Why? Because the Moblex told, have you filed any application with the tribunal or any court? No. In that case, rejected. Then the Moblex went appeal to the Honorable Court, Supreme Court, against the order of the NCLT. Because as per the section, the particularly the dispute 5.6 and 8 subsection 2 also. Moblex went in appeal before the Honorable Supreme Court against the order passed by the NCLT. NCLT declined and Moblex approached the apex court. The Honorable Supreme Court allowed the appeal. They have allowed the appeal by Moblex while interpreting the expression of existence of dispute under section 8, subsection 2, clause A of the Insolvency and Bankruptcy. So they are interpreting the expression. What they have mentioned, what is meant by existence of dispute, as mentioned in section 8, subsection 2, or clause A of the IBC code. Then they go into the details. The Honorable Supreme Court opined that the breach of NDA, non-disclosure agreement, was sufficient to understand the existence of dispute. That's why at initial stage, what are the various types of disputes that are arising? How the buyer or the supplier bypassed that agreement. In case of the agreement is bypassed, what penalties are to be paid either by supplier or the buyer? in that particular situation, first we have to go through the agreement. The agreement reached by the buyer or the seller in case of a goods supplied or services rendered by them, then we have to go through the agreement. In the agreement, the terms and the conditions of the contract clearly spelled out. Once we have gone through that one, then we can arrive a conclusion whether it is a existence of dispute or not. Then we have to go through whatever the sections are there, section 8, subsection 2, and clause A of the particular IBC code. The Honorable Supreme Court was opined that the breach of a non-disclosure agreement, that is sufficient. Whether a disputed existence, a dispute is there or not, it is very easy to, if at all agreement is not there, then some doubts will arise. Once the Mobilex and Kurusa, the NDA agreement is there, non-disclosure agreement, then sufficient to understand the existence of dispute. That is the wordings of the Supreme Court of Honorable Supreme Court of India to invalidate the CIRP application. To validate or invalidate the CIRP application filed by the operation. That is sufficient. Okay. Once NDA agreement, non-disclosure agreement is there, we will go through that one, whether he is bypassed that agreement or not. Once the dispute is there or not, existence dispute is there or not. If the existence dispute is there, the CIRP not allowed. Otherwise, the CIRP is to be allowed for that particular the Mobilex. But here, section 8, subsection 2, clause A, what it reads? The modification of the section 8, subsection 2, clause A, what it denotes? An operational creditor may, on occurrence of default, deliver the demand notice of unpaid operational debt or a copy of invoice demanding the payment of the amount involved in the default to the corporate debtor in such a form or manner as may be prescribed. Whenever the operational creditors they are sending any demand notice, it should be a structured one. What is the structure? Whenever the goods are supplied or services are rendered, the invoice has to be sent to that particular person. Second one, transport document. What is a transport? So the goods are provided to the corporate debtor by way of RR, railway receipt, or LR, lorry receipt, or bill of lading, PL, the shipping authority, or airway bill of lading. If the goods are supplied by air, all the transport document is also to. Not only that one, the goods delivered note. Once the goods are reached to that particular corporate debtor's office, they will acknowledge the goods. This strengthens the particular case, particularly whether to admit or not to do admit by the adjudicating authority. That is the process. Whenever a dispute arises, then all these things one by one they will look into. So the operational creditor may, on the occurrence of default, deliver a demand notice of unpaid operational debtor, copy of the invoice demanding the payment of the amount involved in the default of the corporate debtor in such a form and manner as prescribed. Simple. Once you are raising the demand, the supporting documents are also required. For supporting documents, particularly in case of supply for goods or services, the invoice is a primarily one. The transport document, the goods provided to the corporate debtor by way of lorry or whatever the other modes of transportation. Not only that one, once the goods are received, they will give the acknowledgement. The stores department of the company, they will give the acknowledgement. That is also to be preserved. And the corporate debtor shall be within 10 days of the receipt of the demand notice. Once the operational creditor has sent the demand notice by enclosing all these things. The corporate data within 10 days of the demand notice of the invoice mentioned in subsection 1 brings the notice of the operational creditor. Immediately within 10 days, there is no extension of a time like that. Even Honorable Supreme Court of India also clearly told not exceed that the time should not be exceeded. Time they will mention as a status quo. So the corporate data shall within period of 10 days, the receipt of the demand notice or copy of the invoice mentioned, bring it to the notice of the operational creditor. Then he has to tell whether he has they paid that amount or any dispute is there or not within 10 days from the date of acknowledgement of that particular demand notice. Then the existence of dispute. Here I have mentioned one when it was changed. If any or earlier and is there, if any and is there, and is replaced with or. Record of the pendency of the suit or arbitration filed before the receipt of such a notice or invoice in relation to the dispute. And I mentioned the two words. Earlier, repayment is there. The repayment is changed with the payment and unpaid operational debt. So here, the existence of dispute or record of pendency of the suit, if at all any pendency of suit is there, arbitration proceedings are there, with regard to that dispute, that he has to brought to the notice of the operational creditor by the corporate data for the reply of the demand notice. And the payment, once the earlier repayment is there, repayment is not suitable, then they revise it that payment made or not for unpaid operation. Once the paid amount, how they are paid? By sending the attested copy of the electronic transfer. Once the amount is paid, then whatever RTGS, whatever the NEFT, whatever the check, Xerox copy, attested one for the unpaid amount by the bank account of the corporate data, and or by sending the attested copy of the record of the operation creditor as encashed the check issued by the corporate data. If at all corporate data at the time of supplying the raw material, if the corporate data has issued the check, that is also encashed by the operational creditor, then the account statement is signed and this check was debited on so date. Like that, he has to send the proof to the particular operational creditor. Explanation. For the purpose of this section, demand notice means a notice served by the operational creditor to the corporate data demand payment. Not earlier repayment is there. Repayment is not a correct word and repayment is a correct word of the operational data in respect of such default was occurred. So these changes earlier, particularly if any under the suitable substitution is there and repayment substituted with payment. These are 6/6/2018. It is slightly modified the definition of section 8 subsection 2 and clause A of the IBC code. Next, the interpretation. The word and occurring must be read as or. Earlier, they put and. Now, that is changed with or. For that also, some rational, some reason is there. What is the rational or reason to replace the and with the or? According to earlier interpretation, the and is there. The code provides dispute between operational creditor and the corporate debtor would only be valid if the suit and arbitration proceeding with respect of the dispute has been filed before the receipt of the demand notice. Compulsory. Not only dispute, but also they have to file either any court or labor court or whatever. Labor court. Why we are talking about labor court? Because the employees' salaries, there are also operation creditor, administrative salaries for employees. All these things are there. So, if and is there, not only the dispute, but also they have already filed the case in the various judiciary authorities. The Supreme Court was opined that understanding shall lead a great hardship. As a corporator would then be able to stave off, avoid to delay something dangerous. If fund is there, then it is a dangerous. The bankruptcy process provided a dispute is already pending in a short arbitration proceeding. Once that is there, I am not there. I'm not there. Nobody will touch my company for under IBC code by the operational creditor. Once the default is happened, if it is filed, then automatically these companies are excluded from the purview of the IBC code. So that's why the Supreme Court was opinion that such an understanding shall be lead to great hardship. If fund is there, then it is a great hardship for as the corporate debtor would then be able to stave off means the avoid or delay of something or dangerous. The bankruptcy court provided dispute is already pending in a suit or proceeding. Then he will not come under the purview of the CIRP process, particularly with regard to the operational creditor, because operational creditors are much more than the financial creditor. Financial creditors are less, operational creditors are more. Yesterday we have discussed about that one also. The difference between a financial creditor and operation, why the code is giving preference to the financial creditor when compared to the operational creditor. An important point was highlighted by the Honorable Supreme Court, stating that if the and mentioned, if and is there under section 8 subsection 2 clause A is not read as a or, such a person shall be excluded from ambit of section 8 subsection 2. That's why they removed that and replaced it with or. And application CIRP shall easily obtained and not intended for this. So an important point was highlighted by the Honorable Supreme Court, stating that if the and mentioned under section 8 subsection 2 clause A is not read as or, such persons are excluded from the ambit of the section 8. That's why they have suitably changed that particular in the modification also they have changed from and to or, that repayment to payment. Such a person shall be excluded in ambit of the section 8 subsection 2 and the application CIRP easily be obtained and what's not intended to the district. The Honorable Supreme Court held that existence of dispute and suit or arbitration proceedings necessarily the pre-existing. Once that is a suit is filed, arbitration there, definitely the pre-existing, clearly it is defined to say it is exist prior to the receipt of the demand notice. Once that is there is no need of the particular dispute is there or not. It is very clear. Once it is existence of dispute and suit, arbitration, etc. The Honorable Supreme Court, while deciding the matter, scrutinize the background of the IBC code. Again, the background of the IBC code. They verify the background of the IBC code. It is observed that the insolvency bill 2015, the bill before passing the act, the code, the bill dispute as a bona fide suit or arbitration proceeding. Bona fide suit or arbitration proceeding, they defined. After that, they removed that one. However, the bill was passed, the term dispute under section 5 subsection 6 was dropped from the definition. Dropped from the definition. The Supreme Court stressed upon the interpretation and in the previous law with respect to the dispute does not apply to the current code. In the current code, it is not applied. What will be applied? The will be applied believable or plausible contention. Instead of Honorable Supreme Court provided the new test or believable, plausible contention to determine the existence of the existence of law. So that's why whenever this dispute is arised, dispute is there, then whether it is believable or not. How to believable? If at all agreement is there, or any case is filed, or based on other factors also, we can believe whether it is an existence dispute or not. Instead of Honorable Supreme Court provided a new test, that is believable or plausible contention to determine the existence of dispute. Next, whenever the operational creditor is filing an application with the NCLT, the NCLT will verify the documents. The process to be seen by the adjudicating authority. While examining any application under Section 9 of Insolvency and Bankruptcy Code, first, whether it is more than 1 crore or not. Okay, in case of workers and salaries, that is a different issue. So 1 crore or not. Second, the documentary evidence is to be provided. As I told earlier, the documentary evidence is invoice, transport document, and the goods received, acknowledgement, and whatever the correspondence resting on that particular subject between the buyer and the seller, either by way of email or registered post letters, etc., shows the debt is due to payable has not been paid. The third one is whether there is an existence of dispute between the concerned parties or any record of a pendency or suit arbitration proceeding filed before the receipt of the demand. Before receipt of the demand. Before receipt of the demand. Not after receipt of the demand. Before receipt of the demand notice. That's why today in NCLTs, while admitting the case, they are asking the declaration or affidavit from the operational creditor. They have to confirm whether there is no existence of a dispute while providing the goods or services to the corporate data. Later on, if at all anything happened, then they will take into serious. Why? Because a judicial time should not be wasted for all these things. Next, if any one of the conditions are not satisfied, satisfied, NCLT must rescind the application. So whatever the conditions are there, the proof, the demand notice, and the existence of that particular dispute, if all are there, then they will accept, otherwise they will rescind the case. Conclusion. There appears no doubt in interpretation with respect to dispute and existence of dispute. It has been quite a debate since inception of the code. From the inception of the code, everybody is talking about the existence of dispute and the dispute what. Then, due to this landmark judgment, that point is clarified by the Honorable Supreme Court of India. The conflict of interpretations have been provided in different benches of. Once that is not clarified, still it is lingering. Definitely, the everybody will view in a different manner, and thereby the time delay and all these things will happen. However, conclusional ruling by the Supreme Court has finally provided a settled position. Now people are the confirmed. Then one standard is designed on account of the judgment given by the Honorable Supreme Court of India. So the conclusion ruling of the Supreme Court has finally provided a settled position. If that is not happened, the Mobilex or particularly the Kurusa, his judgment is not happened, then different NCLTs viewed in different manner and different judgments and no synchronization, no correlation, and a lot of time waste and other things are happening. It would be interesting to note that various NCLTs would interpret and apply this landmark ruling relating to plausible conjunction test. Now, plausible conjunction, believable or plausible, believable contention test. Moreover, the Supreme Court has been vigilant to highlight the strict adherence of the timeline provided. They have not touched that 10 days or anything. If at all 10 days is touched, then automatically the total time schedule given for CIRP process, that is 180 days, that is also becomes some problem will be they have not touched and the resolution plan to be completed within the time schedules. The Supreme Court has clarified the object of court, keeping in mind that the legislative intent. The court, through the judgment, provided a balance between the rights of the creditor and also remedies to the debtor companies. Through this Mobilex and Kurusa, they have given a balance between the rights of the creditor and the remedies to the companies. But in this case, one more case is also there. That is called Wipro case. The IT company Wipro, or Wipro, not only IT company, other other products are also there providing Wipro, particularly electrical side also, or consumer durables also. They are fast moving consumer durables also they are providing. One Wipro case also for understanding that particular existence of a dispute. NCLT dismisses the operational creditors insolvency plea against Wipro. NCLT dismisses the operational creditors insolvency plea. Operational creditor filed against the Wipro. Wipro has not paid the amount. Up to certain amount they paid, certain amount not paid. Immediately, the operational creditor filed an application with the NCLT. NCLT admitted, but the NCLT not admitted, and the appellate authority, they approached the appellate authority, they are also dismissed. But what is the facts of the case? The National Company Law Appellate Tribunal dismissed the operational creditor petition for initiation of the insolvency proceedings against the Wipro Limited. The two-member Chennai bench appellate tribunal held earlier that there was a pre-existing dispute over the payment between Wipro and the petitioner, and observed that the insolvency bankruptcy code was not framed for being a mere recovery resolution for creditors. If at all any disputes are there, it is out of the purview of the IBC code. It is not a platform for a recovery of dues or resolve the whatever the disputes are there. The object and the preamble is entirely different. So the two members of the Chennai bench of the appellate tribunal held earlier that there was a pre-existing dispute over the payment of a Wipro and the petitioner, and observed that the Insolvency and Bankruptcy Code was not framed for being a mere recovery registration of the creditors. The National Company Law Appellate Tribunal upheld the order of the NCLT. And earlier, Bangalore Bench NCLT Law Tribunal January dismissed the plea of Tricolite Electrical Industries in the capacity of the operational creditor. The Tricolite, the operational creditor of the Wipro, they filed an application with the Bangalore, and particularly they are also particularly earlier the Bangalore bench NCLT January dismissed the plea of the operational creditor Tricolite Electrical Industry in the capacity of the operational creditor. The order was challenged by the Delhi-based operational creditor. The Tricolite is a Delhi-based operational creditor to a manufacturer of high tension or low tension electrical panels, LT and HT panels, before the appellate body, that is NCLT. They have supplied this low tension and high tension electric panels to the NCLT. However, the NCLT also dismissed after observing that we are satisfied that the dispute is truly existed for the respond company Wipro to have been withheld 3% of the total invoice amount. Out of the total amount, 100% amount, the Wipro is already paid 97%, and 3% they have not paid, and that is they have put it in one withheld that 3%, because based on the terms and the conditions of the contract. The terms and the conditions of the contract is, if at all the customer is not satisfied with the performance of the Tricolite, then we don't want to pay the 3%. Once the customer is satisfied, 100% we will pay the contract amount. 97% they paid, and 6 months the waiting period. After 6 months, if at all the customer raised the services provided by Tricolite is not up to the mark, then they are not eligible for 3%. That's why the Wipro is given the subcontract to the Tricolite. So then the customer of the Wipro not satisfied with the performance of the Tricolite, then the 3% is held up, not paid by the Wipro. Under the IBC, the insolvency process against the corporate debtor is generally initiated by only the clear cases. That's why today, most of the NCLTs, they are taking the declaration or affidavit for any existence of disputes is there or not. This is not the form, particularly NCLT is not addressing the recovery or dispute mechanism. The objective of NCLT, the formation of the IBC code and the formation of the enactment of IBC code and formation of NCLT is entirely different. And real dispute between the parties did not exist. The dispute related to supply of goods for the government project implemented by Wipro. Wipro is the main contractor, and they have given subcontracts to the Tricolite also, particularly high tension and low tension electrical panels they have to install. Where it was about the work design, manufacture, supply, and installed by the MA Finance. Pursuant to the Wipro had placed and purchased order for total supply worth of 13.43 crores. The total contract is 13.43 crores. According to appellate, supply of goods in timely manner and raised the various invoice. The Tricolite they have timely completed the task and invoice are also raised, for which Wipro made 97% of the total contract, but 3% of the total value of invoice, which is a substantial amount, was kept outstanding, not paid. But if you refer the agreement between the Wipro and Trachlite, the subcontractor, then some conditions are there. Once the government is not satisfied with the performance of the particular installation of electrical panels, then the 3% are not eligible. That is a penalty clause. Despite several reminders, it was not paid and did not reply to the demanded notice issued by them. Even though 10 days time is given to the corporate data, particularly the Wipro has not replied to that one also. Despite several replies made by the client, that is operational creditor, it was not paid and did not reply to the demanded notice issued by the operational creditor, that is the client. Wipro denied the allegations, whatever the allegations made by the operational creditor, arguing there is a pre-existing dispute between the parties. Yes, there is a dispute. Pre-existence of dispute is there, which is reflected in the emails. And they have produced all the emails. What is the pre-existing dispute? Why we have not paid the 3%? And whatever my communication is there, from Wipro to operational creator, all emails they have submitted to the adjudicating authority. It is already paid at 97% of the amount. And the appellant had sought question the basis of the right to respond liquidate the damages to the tune of 3% on the contract. Whatever the damages are there on account of wrong services provided by the Trachlite to the government, this 3% they are going to use to rectify the whatever the problems that are faced by the government in electrical plants. The quality of the service provided by the operational creditor is not up to the mark. The waiting period 6 months is after installation. Once after 6 months only, whether it is erected correctly or not. Once they completed and okay sir, all panels are right, all lights are on, means that is not the criteria. So they have to test it. They have to use it. Then only what are the problems. For that 3%, whatever the damages are there, that is to be rectified by Wipro only, and with the help of that 3%, whatever the amounts are there. Agreeing with that, NCLAT said, it is a consistent stand of a Wipro. 97% of the amount was paid, and the balance of 3% was kept on hold on account of evaluating the customer satisfaction. So the contractor, okay, you have completed the contract, but the 3% why withhold means once the contract work is satisfactory up to the satisfaction of the client, then only we will reimburse 3%. Otherwise, that amount can be used for rectifying the mistakes committed by the operational creditor, in this case, Trachlite. Was established there was a delay of 6 weeks on behalf of the appellant and executing job assignment to them on account of liquidated damages penalty to the tune of 40,56,539, which is as per the terms of the contract was levied. Therefore, the tribunal is of the considered view that there is a pre-existing dispute, which is not a false defense and is a mere bluster, said NCLT, bench comprising of just Venugopal and Sirisha Herla. So here, to conclude this one, is particularly the existence of today almost all companies, they are depending on outsourcing activities. Outsourcing activity one, suppliers two, they are contributed a lot to the company. Day in and day out, the creators are supplying the raw material. Some of the people they are providing services, etc., etc. Once the services are provided and the raw material is supplied, they are eligible to get the amount. But if the services are not up to the mark, if the raw material supplied by them, the quality is not up to the mark, the particular packaging is not up to the mark, if the goods are not provided in time as per the contract agreement reached between the buyer and seller, if at all any deficiency of service is there, definitely the penalty will happen, then dispute will happen. And once it is an existence of dispute, then these cases are not to be resolved at the NCLT. And these are the out of the purview of the NCLT. These are to be resolved in civil courts like that. So that's why the earlier, before the Moblex and Kurusan judgment, most of the NCLTs, they are given, they are interpreting the words differently, and thereby the interpretations on account of different interpretations, different judgments or the verdicts were released, and no uniformity in their judgments. And after that, that particular Moblex and Kurusa, so the Supreme Court judgment, landmark judgment, now the uniformity is happening. So this is in brief about the judicial pronouncement one. Now we will take break 10 minutes. After that break, again we will discuss about judgment two. Sir, is it okay for all, sir? Shall we take break for 10 minutes? Sir, madam?
Yes, sir.
Sir, now I am starting this judgment too. So the landmark judgment Supreme Court that is judgment two deals with resolution plans are to be finalized by the Committee of Creditors. So whenever the Committee of Creditors are to be finalized, they have to assess the feasibility study, particularly whether it is viable or feasible to hand over that particular company in the hands of the resolution applicant or prospective resolution applicant or not, that is to be properly decided by the Committee of Creditors. So the commercial wisdom concept was there. Why? Because the financial creditors, whenever they are giving lending to the prospective, the corporate debtor or companies, they will assess in detail the various studies, economic feasibility, financial stability is there or not, great business is there or not, whatever the projections. All these things they will take into consideration, and then only they will provide the particular fund to the companies. So that's why the commercial wisdom is the experience are have they are there for the financial creditors, not to the operational creditors. That's why whatever the decision taken by the financial creditor while finalizing the resolution plan is in most of the cases are correct, but some exceptions are also there. On this only, now I will discuss about the landmark Supreme Court judgment, particularly on the resolution plans, particularly on the resolution plans. The resolution plan. It is a commercial wisdom of COC, undoubtedly. Whether or not rehabilitate the corporate debtor by accepting the particulars of resolution. So the COC has to pay some attention. This is the last stage of the CIRP process. And a lot of attention, lot of accuracy, all these things are to be taken by the COC while accepting or rejecting the particular resolution plan. Otherwise, in case they are not taking a proper attention, sometimes it may lead to liquidation, or sometimes it may square one also. So that's why the commercial wisdom, why it is a commercial wisdom, we are talking about commercial wisdom, because the financial creditors are having a rich experience while sanctioning the loans, while processing the loans, and they are forecasting the particular the borrower in a long run. Suppose they are taking they are giving one loan for 10 years, means they are forecasting the revenue generation, sales projections, what are the costs involved, all these things they are aware. That's why the commercial wisdom of the COC is final in most of the cases, with exceptions are also there. The insolvency resolution is ultimately in the hands of the majority of the votes of the COC. And it may be approved the resolution plan not less than 66%. And financial, after consideration of the feasibility and the viability, that is important. Suppose I am giving one unit, the promoter is having a rich experience, the resolution applicant, the prospective resolution applicant is experienced in chemical industry. But now I am finalizing the resolution plan of one particularly news media. That person is not having rich experience in news media, but the person is having experience in chemical industries or petrochemical industries. So here the feasibility, viability study also. Whenever I'm going to give that one, whether he is having capacity to pay or not, even though we are taking about the bank guarantees and all these things, etc., etc. And some of the people they will tell, once it is a resolution plan is approved, we will pay upfront 25%. I am the eyewitness in NCLT Hyderabad also. Some of the resolution applicant of the finalization, they are not willing to take over the company. Okay, the penalties and other things they will pay. That is a different issue. But the wrong selection by the COC because they have not screened that application properly. So the insolvency resolution ultimately in the hands of the majority of the votes COC two-thirds. And it may be earlier it is 75%. The 66% also originated from the NCLT Hyderabad only. Even though at that time it is not there in the code, they have given a judgment like that 66%. Later on, the code is also changed. Of the voting share of the financial creditors after considering the feasibility and the viability and the various requirements may be prescribed by the regulations also. So all these things are to be taken into consideration while finalizing the resolution plan. What left? Majority decision of the COC is a feasibility viability. Ultimately, the unit goes in the hands of the safest hands, and they have to continue the company. They have to grow the company. They have to deliver the particular whatever the goods are there or services are there, and it supports to the economy or not kills the economy. If at all it is not in the safest hands, again the sickness, again the whatever the problems are there, then employees retrenchment and the production will reduce and whatever the problems are there, all problems again square one. That's why the finalization of the resolution plan is very, very important. That is the feasibility and viability of the resolution plan, which is obviously takes into account of all aspects of the plan. Particularly some of the financial creditors, they will their thinking is restricted. Boundaries are there. That boundary is whenever the amount is recovered, they will accept it. That is not the criteria. What about the operational criteria? What about the other stakeholders? All are to be satisfied in that particular resolution plan. It is not one person that is the financial creditor, the stakeholders of the company. The manner and distribution of funds among the various class of creditors. So that's right. The COC finalization, that is the last stage of the CIRP process with the utmost attention to be paid by the committee of creditors. That is the COC dharma. That is the COC dharma. If at all they have not adhered, if at all they have not justified, if at all they have not given due attention to all the stakeholders, the purpose will be defeated. The objectives of the IBC will not be fulfilled. So the heart of the CIRP is nothing but the finalization of the CIRP process. And we are going to hand over this company in the safest hands of the prospective resolution applicants. For that, one landmark judgment is there that is called K. Shashidhar versus Indian Overseas Bank and others. The K. Shashidhar and versus Indian Overseas Bank. Supreme Court decision is the K. Shashidhar versus Indian Overseas Bank. Address the critical issue in the corporate insolvency resolution. That's why I told this is a final stage. The end of the particular CA, going to be end of the particular CA. The scope of a judicial scrutiny over the commercial decision by the committee of creditors to approve or reject the result. Judicial scrutiny is also required. Okay, that is not ultimate. Whatever the decision taken by the particular the COC is not the final this one. Then the judicial authority also once or twice they will verify whether all stakeholders are satisfied or not, whether they followed the guidelines or rules, the regulations or code or not, and what are the various acts. All these things they have to. Not only that one, the background verification of the particular the resolution of it. That is very much required. Even as a banker, whenever we are giving loans to the prospective borrowers, we are doing a lot of exercise. Still, some of the loans are turned into non-performing case. And but here, the verification, thorough verification is very much required. That is a role of the COC. Not simply once 10 applications are preparation of evaluation matrix, adopt the finalization, who is giving a higher amount or who is giving paying the first amount, who is bringing that the offered amount more. And if at all some people they are always preferring to pay the financial creditors, and all the stakeholders have to be satisfied. All regulations or code are to be fulfilled, and a thorough verification once or twice the prospective resolution. Some of the resolution applications, they're no, they withdraw. No, I don't want to the company now. Earlier you told, and we have finalized. Now, if you are telling, no, I don't want to take the company, means again the delay will happen. The time value of the money, all these things are there. Okay, even the penalties and whatever the amount is there, we will recover. That is a different issue. So here to approve, that's why second script is there. Second I concept is there. The second I concept is none other than the NCLT. The first I concept, that is a COC, and the second scrutiny or I concept is EYI concept is the NCLT. The Supreme Court passed a common judgment in appeals arising out of the decisions of the NCLT in the matter of Innoventive Industries and Khomeini Steel Power Limited, Khomeini, re-emphasized the COC autonomy in the matters of approval or rejection of a result. They're having autonomy. Nobody will intervene. Nobody will intervene. Their judgment is the final. It doesn't mean always not, but subjected to. Their judgment is final, correct. They are having the commercial wisdom, their judgment is final, but subjected to 1, 2, 3 like that. So the COC autonomy in the matter of approval or reject the resolution plan based on the commercial judgment or decision. The Supreme Court re-emphasized about the importance of the resolution plan that is to be finalized by the COC as well as by the judiciary authority, that is the NCLTX. In an Innoventive resolution plan, as a guard approval only 66.57 of the COC voting sheet. Only at that time 75% is the minimum. At that time, the minimum 75%. Okay. But the arrestable management raised some issue. Then I went to set aside the resolution plan, reject the resolution plan by the certain members of the COC on the grounds that it is being malicious and without any valid reason. Some of the people, they rejected. This resolution plan is not correct. Today, practical, I am talking about a practical. Some of the valuations are not up to the mark. and the valuations are more, the less valuation, and the resolution profession, the resolution applicants are very much interested to take over the company once the wrong valuation is there. That is why some of the people, whenever I'm they going to the NCLT, the arguments are like that. The valuation is not up to the mark like that. So, in the innovative resolution plan, had got the approval of the 66.57 of the COC by voting share. Erstwhile management innovate to sort to set aside the rejection of the resolution plan by certain members of the COC on the grounds are being malicious and valid reasons. The National Company Law Tribunal ordered liquidation in this case because only 66.57 and 75% at that time, then the liquidation order is passed in one case. Second case, Kamineni, the NCLT approved the resolution plan. Hold that 78.63% of the COC voting rate are approved the same. It did not, however, take into account of the votes of the COC who has abstained and not participated in the voting rate. That is must, because it is a final stage. And all members are to be attended and they have to give their voting. Some of the people are abstained or not participated. And whatever the people are there, out of that 78.63% voting is there, the NCLT directed liquidation in both cases. As the respective resolution plans has not been approved by the requisite majority of 75% as then applicable at that time, of course. The Supreme Court dismissed the appeal while upholding the NCLT decision. Some of the people again they approached the Honorable Supreme Court of India. The NCLT decision is upholding the NCLT decision. And great emphasis of COC autonomy in the matter of approval or rejection of a resolution plans based on the commercial judgment or a decision. And a great emphasis was given COC autonomy in the matters of approval or rejection of the resolution based on the commercial decision or judgment. Even Supreme Court of India also, they won't involve in the commercial judgments because they are the experts. The financial grades are experts. They know the feasibility and the viability of that particular company. Who is the best? Who is the worst? But with some exceptions, with certain conditions, with certain riders. The judgment of the Supreme Court. Supreme Court at the outset provided much needed clarity on the scope of a review of NCLT of the resolution plan as approved by the COC and held the NCLT's jurisdiction is limited to the NCLT being satisfied that the resolution plan met the requirement of section 30 subsection 2 of the code. So here, the Supreme Court is outset to provide the need clarity on the scope of the review of the NCLT. What is the scope of the NCLT? What is the role of the NCLT? While accepting or rejecting the plan approved by the COC. What is the role of NCLT? First, let me discuss about that fact. Of the resolution as approved by the COC and held that NCLT's jurisdiction is very limited. The jurisdiction is very limited to the NCLT being satisfied that the resolution plan meets the requirement. If at all the plan is meeting the requirement as defined in section 30 subsection 2, if it is satisfied, then simply they have to approve that one. Because the commercial wisdom is vested with the COC they will go to in detail of the viability study or feasibility study of that particular resolution applicant of the insolvency and bankruptcy code. This namely, particularly that section 30 subsection 2, what it is, PAN contains the provisions relation priority of payments as prescribed. This is the priority of payments. The priority payments also clearly defined in the code. Even in liquidation also, waterfall mechanism priority of payments is also clearly defined. So the priority of payment as prescribed in the code, in the resolution plan also, they have to give the priority like this. Whatever the insolvency resolution process costs, what are the unsecured, secured, or like that, whatever the priorities payments are there, that is to be adhered or not, that is to be verified by the NCLT. Management of the corporate data. So the management of the corporate data, whether the particular resolution applicant will handle that particular company or not. Some of the resolution applicant, they don't have the experience and they are going to take out the company, and the ultimate result will be not up to. If at all the relevant people are taken, if at all textile industry, if another textile industry promoter are going to acquire with company, the results will be more because they are in the line of activity. Implementation, supervision of the resolution plan. We will verify if at all they have given 3 years and they have given a plan also. And I will brought this much amount on so and so data, and I will implement the latest technology in the company. All these things they will mention in the resolution plan, whether they are adhering or not. That is to be verified by the implementation supervision and the compliance with applicable law and nothing more. Whether all comply with all the laws or not. So that's why, if you see the section 30 subsection 2, these are there nothing else. So the judicial authority, that is NCLT, they have to verify this one. And if it all are okay, then they will sign. They don't enter or encroach in the commercial aspects of the, because the COC is a competent person in taking the decisions of the commercial areas. The day one onwards, they are well versed and they are born and brought up in that area. That's why the commercial wisdom, nobody should encroach. Even Honorable Supreme Court of India also, they are not intervening in this commercial wisdom of this one. Hence the role of NCLT. While considering the resolution plan has been clearly circumvented, there is no ambiguity. There is no ambiguity, nothing. The role of NCLT while considering the resolution plan has been clearly defined. That is the section, that is subsection 2. They will go through that one. Why? Because if it all viability and all these things are also there with NCLT, even 180 plus 90, 270 plus 60 extension in exceptional cases, 330. 330 days is insufficient. Another 2 years are required because courts are busy with various activities. When they will have time to verify all these things. So that's why they have given that assignment, they have given that function to the Committee of Creditors. Hence, the role of the NCLT while considering the resolution has been clearly defined. The Supreme Court further observed that the legislature, while enacting the code, consciously ensured that no ground is available to question the commercial wisdom. Once they're asking how you are selecting so many matrices there, even evaluation matrix. Through evaluation matrix also, a lot of parameters are there, and the awarding of marks are also there. Okay, even though one person is got the highest marks, it doesn't mean that we have to allot it to him. That is not there. But for our comfort's sake, for evaluation purpose, the most of the companies, most of the RPs, they are using the model evaluation matrix. So the Supreme Court further observed that the legislature, while enacting the code, consciously ensured that no ground is available to question the commercial wisdom of the individual financial creditor or collective decision of the CFOs. Before NCLT is approving or rejecting the resolution plan, such commercial consideration is outside the scope of the judicial review that is clearly defined. It is not under our scope. It is under the scope of the CFOs. But still, some of the CFOs, some very few, they are doing wrong things. Because once the power is given, the power is to be used for good purpose, not for the bad purpose. So the power is vested, the commercial business power is vested with the COC, and not even judiciary authority also. They have to use that power for good things, not for bad things. And however, the Supreme Court did clarify that COC was rejected a resolution application. If at all COC is rejected, the application not accepted for any grounds mentioned under 30 subsection 2 of the code, including the decision on the eligibility of the resolution applicant under section 29A. If at all any prospective resolution applicant is rejected at 29A, said the decision subject to judicial. Once they have finalized, accepted, nobody should intervene. It is a commercial wisdom. But judicial review is there. When once they have rejected the resolution plan, all resolution plans, and they have rejected the prospective resolution plan, and they told that they are not eligible under section 29A of the code. In that particular situation only, the judicial review is there. Otherwise, no intervention in the commercial wisdom of the COCs, particularly in finalizing the particular resolution plans. The Supreme Court held that amendments to section 34 of the code, June 2018, which introduced the requirement of COC to consider feasibility and viability. Earlier this is not that. That is required also. Once I have given a power, the power to be vested in this particular broad parameters only, that is to be defined. Otherwise, I may misutilize the power. As a COC member, I may misutilize the power. The feasibility and viability. Earlier it is not there. So the Supreme Court further held that amendment to section 30 subsection 4 of the code in June 2018, which introduced the requirement of the COC to consider the feasibility and the viability of the resolution before approval, is merely restatement of the factors of the COC is expected to take into consideration in any event while considering the resolution plan. Some of them are even in the bank also. We are appraising the projections. We are appraising the financial strength of the company. We are appraising the value and the collateral security offered by the beyond all these things, the character and conduct, the capacity of the borrower, which is not readily available, character and conduct. Then we will verify the CIBIL. What is the credit history? That also we will look into. Here also, in the resolution plan, if at all they have given all these things, and we will bring this much, and we will implement this technology, and we will complete this one within the, whether he is capable or not, that is to be, and whether he is having that much skills or not, that is to be a price. Some person, one resolution plan submitted, all are high. I will bring a higher amount. I will put this technology, all these things. Whatever the guarantee or whatever the conditions are there, he is satisfied. And if at all that capacity is not there to complete, to handle that particular company, we should not. So that's why the feasibility, viability is a broader term that they have to, while finalizing the resolution plan, the COC has to consider the feasibility and the viability. One side in the court or judicial pronouncement, the commercial wisdom commission, but they have put a rider also. What is a rider? The rider is feasibility and viability to be considered. That is a broader term. That is a broader term. Additionally, the Supreme Court also held that amendments to the code reducing the voting percentage resolution plan from 75 to 60, as well as the requirement of the recent approval rejection, prospective, not retrospective. So whatever completed, that is not to be taken into consideration. It is a prospective, not retrospective. And the decision already taken by CS prior to the amendment cannot be undone. So here also, the Supreme Court clearly told this is the percentage is a prospective one, not a retrospective one. Analysis. The judgment outlines the limits and the scope of challenges. Outlines, particularly this judgment is giving what are the broader parameters, what are the limitations and the scope, and what are the challenges can be against the decision of the financial creditor and the COC in approving or rejecting the resolution. This judgment is given the outer parameters, the limits, what are the challenges they are going to face, all are covered in this particular landmark judgment. When prima facie COC decisions in either approving or rejecting the resolution plan was recognized the foundation of the code by the Supreme Court. So, while prima facie the COC decisions either approving or rejecting the resolution was recognized, yes, they are capable person. Undoubtedly, this structure not to be changed. The financial creditors, the who are having the voting right, then they can accept or reject the resolution plans that are submitted by the prospective resolution applicants by the Supreme Court, as well as the Bankruptcy Reforms Committee also. They are also felt today there is no question of operational creditors. The resolution plans is the part of the, if at all more than 10% of the claims is there is a part of the committee of creditors, but is not having the voting right. But the financial decision particularly the final decision, which is a crucial one, which is the heart of the CIRP, is finalizing the resolution plan. That the power is vested to the committee of the creator. That is recognized by the Supreme Court of India as well as Bankruptcy Law Reforms Committee also. In the previous rulings, the decision put into issue beyond a doubt of the commercial decision and COC is non-justifiable and will not open for scrutiny by the NCA. That's why whatever the commercial decisions are there, that is not to be reopened by anybody. So the well recognized and the Bankruptcy Law Committee also recognized that is authority to be vested with the COC. So it brings much desired clarity. A note of caution must be added that the judgment does not make all decisions or duties entrusted upon the COC under code non-justiciable. So while bringing the more desired and clarity, caution must be added. That is, the caution is the viability and feasibility. The caution is they have to adhere all the, they have to verify whether that prospective resolution applicant submitted the resolution plan is provided to all the stakeholders in a reasonable manner or not. As a control of the corporate data shifts to the creditors in the insolvency, the decision taken by the COC in the course of resolution plan impact and affect the rights of all the shareholders. The control of the corporate data shifts to the creditor in insolvency. The decision taken by COC in the course of resolution process impact and affect the rights of the shareholders. The role of the COC is the resolution plan process must therefore be balanced responsibility and duties towards all such stakeholders. The balanced responsibility. While accepting the resolution plan, they should not only focus on the operation or the financial creditor, they have to give and due weightage to other stakeholders also. Those who are satisfying all the stakeholders, it is better to accept that type of resolution plan instead of only certain stakeholders. Next, the decision of the Supreme Court in ArcelorMittal Limited, India Limited versus Satish Kumar Gupta and others, and the Swiss Rubbers Private Limited, India, have laid emphasis on the responsibilities of the COC. They have given emphasis on the responsibility of the COC inter alia, ascertain the legality of the resolution plan and the eligibility of the resolution applicants. In these two cases also, the legality, the eligibility of the resolution applicants, whether they are eligible or not. Even if at all any the expression of interest or request for resolution plan is given, anybody can apply. Anybody can tell something subject to net worth and other things. But the eligibility of the resolution applicant, the line of activity, the competency, the experience, and net worth, all these things have to be taken into consideration. Because I'm handing over this company in the safest hands, not the wrong hands. I should not hand over the company in the wrong hands. Safest hands. then only the objectives of the IBC will be fulfilled. With the liquidation being the last resort and safeguard the interest of the creditors. And the resolution plan must provide fair and equitable treatment to all operational creditors. They have to give the fair treatment to operational creditor because they are the poor people. Even the financial creditors are providing money, they are providing raw material. We should not deny that people. For running the company, both financial creditor and operational creditor are must. Without operational creditor, the company will not run. Without financial creditor, also company will not run. Okay. The distinction between these two people are different. So many differences are there. But it doesn't mean while accepting the resolution plan, we should give this reasonable importance to the operational creditor also, even though they may be unsecured creditors. For lifeline of the company, for running of the company, operational creditors are also providing the raw material. Once they are supplying the raw material, the wheel of the company will move. Otherwise, the wheel of the company will not move. Well, commercial decision of the COC in evaluating the resolution plan is protected from judicial scrutiny. That's why lot of responsibility, lot of accountability that is to be fulfilled by the committee of creditors. That is the COC Dharma. That is a final decision they are going to take. Once the wrong decision is taken, then the problem will come to the square one. The problem will come to the square one. So that's why the commercial decision of the COC in evaluating the resolution plan is protect the judiciary scrutiny, no scrutiny. Because they covered all these things, simply saying the commercial part, they don't intervene. Whether NCLT or NCLAT or Honorable Supreme Court of India. The decisions while performing such other responsibilities by the COC in the course of resolution remain subject to challenge under the 60 of the IBC. The 60 of IBC, whatever the parameters are there, if that parameters are not fulfilled and passed the resolution, it is subject to scrutiny. Otherwise, it is not subject to scrutiny. So that's why the section 60 scrutiny, if at all they have not fulfilled that particular parameters, then whatever the resolution plans are accepted, it is subject to scrutiny. The judgment is expected to reduce the time scrutiny. Once the scrutiny time is also vested with judiciary authority, when it will be released, nobody knows. Today, whatever the time schedules are there, the time schedules are not adhered. It is a judicial delay or other delay, that is it is expected to reduce the time of scrutiny of the resolution plans and pave the way to faster and of the resolution plan. Some cross-talking is there, man. So here, the judgment is expected to reduce the time for scrutiny of the resolution plan. Once the scrutiny is also in the court of particularly with the judiciary authority, then lot of time will take. And paved is the way of faster, timely approval of the resolution and the commencement of the liquidation by the NCLT. That's why, particularly this commercial relations, COC means the time span or approval of the resolution plan by the judicial authority is quick and immediately they can dispose of that one. They can dispose of that, but have to one resolution plan during it was approved initial. Sir, I have given one resolution plan during May 21. It was approved in. Sorry, that's why judicial delays are there. We should not question them. Even though I am handling this personal guarantee to corporate data, that is Deccan Chronicle, PK Iyer and Ravi Kumar, Vinayak Ravi Kumar Reddy, like that. And others are also there. It was filed 2 years back. Till date, it was not admitted. Even though we are telling about resolution plans and all these things. Once admitted, okay, the result may be positive or negative, that is a different. When the bank will get the funds, that is a question mark. So the judgment is expected to reduce the time scrutiny for resolution plans and pave the faster timely approval of the resolution plans and the commencement of liquidation by the NCL. Not only this one, ArcelorMittal India Private Limited. So here, even though all these things are given, but still the resolution plans in some of the cases not up to the mark. One case I am witness whenever I am approaching the NCLT, they are even after 8 years, months, not approved. This plan approved COC 96 reasons with it. With this 1.5 coming each other opposing, hence the judge could not decide. So here said, that's why whatever the powers are given, the powers are to be used as per the objectives of the court, and the powers are not to be misutilized. And once any favoritism is there out of the resolution plans, because the commercial wisdom vested with the COC means if the COC is having any vested interest, then automatically the total problem will arise. In some cases, that is also happening, and all these things are there, but the courts are not encroaching in the commercial decisions of the COC, but at the same time, some riders are also mentioned by the courts. Even though we have given power, but the power should not be misutilized. That is feasibility, viability, and whatever the riders are there, the Supreme Court of India or the NCLT or NCLAT, they are always mentioned in the judicial pronouncement. The same was particularly this type of cases are there, particularly ArcelorMittal India Private Limited versus Satish Kumar Gupta and others. RP is not empowered to decide whether resolution plan contravenes any provision. We should not encroach. We will see the reports. We will prepare the particularly evaluation matrix, and we have to present the same to the COC. COC will take a call. We are only the administrators. We are only the facilitators. We are not the judiciary or others. And the call is to be taken by the particular COC only. And RP is not empowered to decide whether resolution plan contravenes any provisions of the law or not. In Swiss Rubber Private Limited and another Union of India others, since the financial creditors are in the business of money lending, they are the best equipped assess the viability, feasibility of the business of the competitor. Even though I'm a banker, I'm not favoring that one, but we know whether the particular person is capable or not, whether the particular business going to the handled by the particular resolution applicant or not. We will judge based on our expertise or experience over a period of time. I'm also a financial, particularly the bank. We know how to accept whether the prospective resolution is capable of handling the company or not. Even in Swiss Ribbons Private Limited and the Union of India, others also. Since the financial creditors are in the business of money lending, correct, day and day out, that is our job. We assess the qualities. We assess the strength of the project. We assess the financial strength of the business. We assess the projections of the business based on the trend analysis and all these things. We will assess the collateral security offered by the people. We assess the demand and supply gap of the particular the business, whether the marketability is there or not, how many competitors are there, what is the prevailing price, whether they are incurring losses or profits, all these things, the data as well as the project evaluation qualities are available with the financial creditors. Even at the time of granting loan, they undertook the detailed market study. This is not my version. This is the Swiss Ribbons Private Limited and Union of India. They have defined. That's why the power is commercial wisdom power is given to the COC with some riders. And the detailed market study, which includes the techno-economic evaluation report, evaluation of the business, financial projection, etc. They are good position to evaluate the contents of the resolution plan. That's why the commercial wisdom. That type of skills are may not be there with the operational creator. Because they are only supplying the raw material. They are not the lenders. They are not the lenders. They don't know the market trends. They don't know the potentiality of the particular product. They don't know about the creditworthiness of the borrower. They know some extent, not too much. And they may not aware of the financial the ratios or particularly financial strength of the company or not. All these things. And the Committee of Creditors Steel Limited versus Satish Kumar Gupta also. In that case, the resolution plan submitted by the prospective resolution applicant must provide for measures as may be necessary for the insolvency of the CD for maximization value of the assets, which may include transfer or the sale of assets or the part of thereof, whether subject to security interest of maximization of value. Once I am going to take the company, later on I should not face any problem. And I have to satisfy number of people. So the resolution plan submitted by the prospective resolution applicant must provide for measures as may be necessary for the insolvency resolution of the CD for maximization of value of the assets, which may include transfer or sale of assets or the part thereof, whether subject to scrutiny or not. In the committee of that particular, the plan may be provided for either satisfaction or modification of any security of interest. Secured creditor may also be provided for reduction in the amount payable for a different class of creditors. Quantum Limited versus Indus Finance Corporation Limited. It is the duty of the adjudicating authority to find out whether a suitable resolution plan is there to be approved instead of going for a liquidation. Liquidation. Once a liquidation means we are going to kill the company. by splitting the various assets and sell the assets individually and to each and every person, and there is no activity, etc. So, if at all possibility is there, try to explore for resolution plan instead of going for a liquidation. The preamble also says like that. Resolution, not liquidation. So it is a duty of the adjudicating authority like NCLTs or NCLAT. Find out whether suitable resolution plan, because anyhow they are verifying that particular plan, not a commercial site, to be approved instead of going for a liquidation. If at all they are going for, they are recommend or rejecting the application, then the adjudicating authority come into the picture and he will verify that one. Here is a Tata Steel Limited versus Liberty House Group. Also, the resolution applicant has no vested right or fundamental right to have its resolution plan considered or approved. So, we are having some borderlines. We should not cross the borderlines. Whatever the lines are there, within the line only, we have to work. That's why we have the facilitator. We are the only a facilitator or administrator only, not nothing else. And whatever the role and responsibilities are defined in the particular and the code also defined under the IBC code, then we have to follow without any deviation. JM Financial Asset Reconstruction Company versus a well-do holding and exports. In that also, persons who are ineligible to file resolution plan under section 29A, IBC and the resolution applicant who did not move to adjudicating authority before the last date of submission of the resolution have no right to raise their grievances with regard to expression of interest, and that too after approval of the resolution plan by the Committee of Creditors. The resolution applicant, he is only submitting the application, not beyond that. And we may call for the COC meeting also. We may call the COC meeting, particularly while finalizing that resolution plan. We may call, if at all he is interested, he can also participate in the COC meeting. In one judicial pronouncement, it is there. It is not my this one. So here, the resolution applicant is merely submitting his tender. It is nothing but a tender system. In the tender system, one will get the particular win in the tender system. In the tender system, why this one is not accepted, why others are not accepted, that type of questions, no scope. In the JM Financial Asset Reconstruction Company, well-do holdings and export private limited also, they clearly told that persons who are ineligible to file the resolution plan under section 29A, IBC and the resolution applicant who did not move the adjudicating authority before the last day of submission of the resolution have no right to raise the grievance with regard to expression of interest, and that too after approval of the resolution plan by the Committee of the Creditors. Next, in Prakash Chand Jain versus Punjab National Bank and others, the resolution plan which is suitable, feasible, viable among all resolutions should be a successful resolution plan. Some of them, they may tempt also. No, I will give upfront in this match. Whether he is going to bring that upfront or not, that is to be verified by us. Verified by us means the COC has to verify. And some of the people, they are eager to win that particular bid. And later on, they will ask to change that terms and conditions of the resolution. That is not correct. Whatever the conditions are mentioned in the resolution plan, that is to be adhered by the resolution applicant. But the successful resolution plan is also clearly defined. One is more suitable. The promoters, the experience, the promoters, the credit worthiness, the promoters, the line of activity, and whether he is a competent person to handle the company or not, and feasible, viable among all the resolution plans should be a successful resolution plan. That is a successful resolution plan. We have to develop the skills, particularly the COC members are to develop the skills for successful resolution plans. So these two are whatever I given today. One is on the resolution plan. Second one is the existing disputes, if at all it is the existence of dispute, how to verify, and resolution plan, how to be approved by the COC. These are the two areas. Why I told the two are very, very important means the operational creators nowadays, they are also filing number of cases in various NCLTs. Only one information I am quoting here, one small story. The Institute of Chartered Accountants of India, the particular head office, particularly their institute, informed to all the chapters across the country, all the chapters across the country. So, Chamber of Commerce, particularly associations are there in almost all places, all important places. So you please call all the people, the chairman of that particular chapter or region. They have to call all the people and disseminate the information of IBC in local language. In local language. So one chairman of the Institute of Chartered Accountant of India, he telephoned to me. Mr. Prasad, if at all you want to give any one lecture to the Chamber of Commerce, Rajahmundry. Rajahmundry means it is in Andhra Pradesh. There number of rice millers and oil explorer companies, groundnut oil, ginger oil, different the industries are also there. So I will call all the members of the Chamber of Commerce. Nearly 150 people are there. Please disseminate the information of IBC to them. Then that is our initiative president guidelines. Then I visited to that particular place. And all people are assembled in the Chamber of Commerce Association. I have given that lecture, particularly the information about the IBC, its importance, and which areas it is to be implemented, and what is meant by financial creditor, what is operational creditor, what is a corporate debtor, what is a COC, when the operational creditor can file an application with NCLT, all this. Once the meeting is over, nearly 5 big rice mill owners, they came to me, sir, I have supplied one biggest rice mill in our place, that is called Lalita Rice Mill, where State Bank of India also provided 1,200 crores funding to that particular rice mill, because of that East Godavari is called rice bowl of the particular country. So immediately he told, I supplied nearly 2 crores worth of paddy, and he is not adhered, and he has bill of exchange all signed, and whatever the invoice I have sent, and I send that a particular paddy also through lorries, and the transport document is there, and they have acknowledged the goods also. Today, till date, there is no dispute about the quality, about the price, about the packing, about the timely delivery, not there. Then even 2 months, he promised me to pay the amount within 30 days. Till date, it was not paid. And this is the correspondence between him and us also, that is also available. That the five people, they want to file with NCLT. Immediately, the chairman asked me, boss, can I handle that one? Yes, why not? Even for that, even IBC, LIA examination is also not required. Take the standard format and issue the demand notice. And the demand notice, along with the demand notice, these documents are to be enclosed. And then once there is no response from that Lalita rice mill, then you file a case with NCLT in located in Hyderabad. Even Andhra Pradesh NCLT also located at Hyderabad. That is called Amaravati NCLT. Then the five people they have given substantial fees to this chairman because of the particularly the code is not popularized or message is not disseminated at the root levels. Even today, PPI is also not succeeded on account of the information not reached to the MSME promoters because they have to originate that particular application. And once they have originated, the rest of the things automatically take care of. Even banks also, once the volume of applications are filed under PPIRP, definitely the acceptance level for PPIRP will also happen. That product, the incipient sickness, initially that product was sick, not popularized, but particularly the IPPI has to take some the measures to popularize the scheme, particularly with the MSME clusters, and inform to the MSME by way of local language letters. Then automatically that product will popularize, and thereby it is not only benefited to them, it is a benefit to the IP professionals. Once the product is picking up, number of chances will increase. So like that, this IBC also on the day, I'm happy. Why? Because nearly five people, they're ready to file because they are not aware of this one. They want to approach the civil courts. They want to approach the civil courts, but they don't know about the importance and the IBC code on its quick resolution. Honestly speaking, and once the demand notice is issued, and they are going to file the case, they already filed by paying the 2,000 rupees the application form and all these things. All are I guided him, the chairman of that particular Institute of Chartered Account of India, Rajahmundry, and he got for each and every person, he got it and they paid nearly 60,000 per processing charges like that. And now after the five people, they approach on different companies, and the, particularly the Lalita rice mill, immediately they checked up what is this IBC and all these things with their the advocates. Then they told about the seriousness of that particular IBC code. Immediately within 15 days, they paid that amount, and the cases are also withdrawn from the NCLT. So this is the publicity, the information to be percolated to all the people, then only results will happen. So this is in brief about the today's discussion, sir. So any discussions are there, sir? Sir, madam? If no discussions or nothing is there, then we will wind up and we will take today's class wind up. Okay, sir. Thank you very much for your patience listening from 2 o'clock to 5 o'clock. And thank you very much for the initiative for giving me an opportunity to discuss about the landmark Supreme Court judgment. Thank you to the institute. Thank you to all. And I wish you all the best to all the professionals for the financial year 2024 and 2025. Thank you very much, sir. Thank you, madam. Madam, I am closing. Hello, madam.